Hello, everybody. Today we're going to be discussing The Right to Prosperity, Episode 8, How the Law Enforcement in Pennington County, certain individuals dictate who gets the right for the pursuit of happiness and prosperity. Remember that the laws of our nation are implemented by the democracy of the people of which they govern. And the United States Constitution, 14th Amendment, was passed by the Senate on June 8, 1866, and ratified into law 2 years later. It granted all citizens of the United States equal protection under the laws, and all of the Bill of Rights and the amendment in the U.S. Constitution was covered in detail in Episode 2. The part that is applicable today is no state shall make or enforce any law which limits the privileges or immunities of a citizen of the United States, nor deprive any person of life, liberty, property without due process, or deny to any person within its jurisdiction the equal protection of laws. One of the benefits of being a United States citizen is that anybody can apply for a business license and have the right to pursue wealth through their own business. And here is a breakdown of South Dakota's business licenses that were granted. Notice that women, if you look on the left side, they make up 48.2% of workers, and they owned 43.2% of businesses. But now if you look on the left side that says ownership, without employees, 26,000 licenses, and with employees, only 3,194. Then if you go to the male section, without employees, 38 per 1,000, with employees, 11,302 businesses. So this proves that even though South Dakota is bragging that they have a large portion of female-owned businesses, in reality, these are the pyramid scheme companies, the multi-level marketing, the mom who stays at home and is running a Tupperware, a Pampered Chef, Mary Kay makeup, or all of those types of businesses. They're not true, legit businesses that are productive to the general state through supporting families and employees. Now, women do very successful in them, but it's false advertising on behalf of South Dakota to claim that their businesses are equally owned by women when only 3,000 businesses have employees and over 11,000 are owned by men. This also goes into play why Judge Connolly was so intent at stealing Rachel's business away from her, because she was a very successful female-owned business. Then if you go down to racial minorities, the majority of racial minorities make up workers. 10% of workers are considered people of color or in ethnic minority groups, and only 2.8% of businesses are owned by them. So if you go to the right-hand side again, ethnic minorities, actually let's go to the American Indian and Alaska Native, 277 businesses owned by them with employees. And if you go down a little bit further, white or non-Hispanic, 18,952 businesses with employees. So this shows that the majority of the wealth coming into the state of South Dakota is 100% through white, male-owned businesses. If you remember going back to Episode 1 and 2, the South Dakota Department of Social Services has been guilty of being biased against Native Americans and people of color for quite a few years now. And they took over 800 children away from their parents just between the years 2010 and 2013 and were found to be guilty. And instead of having the people that represented South Dakota's Department of Social Services be replaced as they should have, they were promoted to head of the agencies. And now we're in the news again. This time, the Department of Justice brought a lawsuit against South Dakota's Department of Social Services in 2010, and they alleged that the DSS was violating the Civil Rights Act of 1964, which prohibits discrimination for employment purposes on the basis of race, sex, color, national origin, and religion. And their primary plaintiff was a gentleman who was very well qualified for the positions of which he applied for, and DSS refused to hire him on the basis of his race, being a Native American Indian. And there were multiple other instances that the Department of Justice brought in this lawsuit as well. Assistant Attorney General Eric Drebend of the Civil Rights Division referred back to Dr. Martin Luther King and said that people should be judged by the content of the character, not the color of their skin. And again, DSS was found guilty of being biased and discriminating against people based on the color of their skin. And subsequently, they agreed to a settlement of $350,000 in back pay and other monetary relief to 60 Native American Indians. Sadly, the gentleman who was the primary plaintiff never got to see this victory because not only did he lose employment and financial ability to provide for his family, but he also passed away before this settlement was reached. So we're going to look at Pennington County statistics. Now, Pennington County is the second most populated county in the state of South Dakota. This is all taken from the Census Bureau, and it has over 114,000 residents. Its largest ethnic group are white, which comprise of roughly 78-79% of the population. And then American Indians are 7.7% of the population. These are very important numbers to remember. The average income was $62,000. The median age for the Pennington County resident is right at 39 years old. So are all Pennington County residents treated equal? And the answer to that question is no. This is taken directly from the Pennington County Sheriff's Report, 2022 Annual Report. And this is a breakdown of the incarcerated people in Pennington County Jail. And they found that 60% of inmates were Native American. Now, remember that Native Americans only comprise 7.7% of the population of Pennington County, and yet they're 60% of the inmates. So what does this tell us? It tells us that Native Americans are very much at a racial discrepancy for justice. You had 6,190 inmates versus the Caucasians, which comprise 78% of the population, and they have 3,676 inmates, or 36%. So what happens when you have a parent that's incarcerated, and how does that affect your socioeconomic status? Well, the Department of Justice, the Office of Justice Programs, has released extensive studies warning states against this discrimination that South Dakota is exhibiting, specifically stating in their report that children whose parents are involved in the criminal justice system face a host of challenges and difficulties: psychological strain, antisocial behavior, suspension or expulsion from school, economic hardship, and criminal activity. So in other words, what the Department of Justice is trying to warn against is that when you incarcerate a parent, you're promoting that behavior in their children just because that's what's been found through all these studies. Now, what's the cost of Pennington County incarcerating all of these Native Americans? And remember that the judicial system was proven to be corrupt and denied all these people due process of law. So what's going to happen now? And the answer is that on average, families paid over $13,000 in court-related costs, with 83% of those family members responsible for paying the bill being women. So if the judicial system is illegally incarcerating all these Native American men, then the women are left to pay the cost. And everybody knows how difficult it is to be a single mother trying to raise children and then have to pay all these court-imposed fees and everything else on top of it. Then what also happens? Well, you're unable to meet your basic needs. You become homeless. You can't have a house even after you're released because now you have a criminal record. Was that criminal record legit, or was it just imposed on you because you have a very biased source of prosecutors, and that's what we're going into detail exposing, is that South Dakota State's Attorney's Office does happen to have some very biased against certain people of color individuals working for their office. And 70% of the families that had difficulty meeting basic needs had children under the age of 18. So now let's talk about Rapid City's homeless crisis. Well, if you get released from jail and you were thrown into jail without having a legit reason, and we've already proven in episodes 1 and 2 how the Pennington County State's Attorney's Office is very biased against certain individuals, including people of color, you become homeless because you can't work, you now have a criminal background, you cannot obtain employment, and you don't have a place to live. So the Rapid City Police Department actually helped with this as far as how many people have been homeless in Rapid City, and 500 people as of January 24th, 2023. Of those 500 people, we're going to go down. 376 were American Indians, and 93 were considered white. Of the families without children, that was actually good. It was 374, but 29 households with children. And of those, it also says of the sheltered, 24 of those households with children were able to obtain a shelter due to private organizations. So now let's talk about what happens with a child when they're in a family with these adverse events that are happening. And adverse childhood experiences are otherwise known as ACEs. And there's been extensive documentation, studies done, and trying to revamp the judicial system nationwide because of ACEs. So there's 3 types of ACEs that children experience, and the one is abuse. It's either sexual, mental, or physical. Or remember that from these previous episodes, we're just going to use Rachel Evans's family as an example. Rachel Evans was clinically diagnosed, proven with police reports and diagnostic imaging, that Timothy John Evans sexually abused her, psychologically abused her, and also physically abused her. So Rachel's children were exposed to all of those from the abuse. And then neglect themselves of the children. And we'll prove in the upcoming episodes how Timothy John Evans was found to have neglected Rachel's 4 children while they were under his care. And then there's also household dysfunction. Now, we've already covered how Timothy John Evans was an alcoholic, and we're going to go into more detail with that later. He implemented a divorce in multiple families, first with Stacy Goulet Evans Clow, and now with Rachel Evans. He abused Rachel with the children there, as he testified under oath, and he's also trying to incarcerate Rachel. And Timothy John Evans has been diagnosed with mental illnesses. So this is not just something that Rachel takes personally because of her own personal experience, but she has worked extensively with the Native American Indians and seeing firsthand the abuse that occurs. And that's why also I've been a stop domestic violence kind of person before Timothy did all this to me. And then on the right-hand side are different concerns that children exhibit after they have experienced all these ACE scores, and the higher the score, the higher the risk of them having issues later. Now we're going to dive into Pennington County Sheriff's Annual Report 2022. Well, they're really proud about Daniel Lewis, and we're going to go into detail about who is Daniel Lewis in this episode. In fact, in 2022, he was awarded the Child Abuse Prevention Award. So who is Daniel Lewis? Daniel married Teresa, and they had 3 children during their marriage. Daniel works for the Pennington County Sheriff's Department, which is how he met Timothy John Evans. Teresa commenced a divorce action against Daniel in March of 2016. While the divorce was pending, custody of the children alternated weekly between Daniel and Teresa. In April of 2018, Teresa began a relationship with a Christopher Garrigan. Daniel learned of this relationship from his children. Remember, all of this is taken directly from the court documents. Daniel Lewis, on behalf of his minor daughter, allegedly, then sought a protection order against Christopher Garrigan. The petition claimed, sworn under penalty of perjury, that Christopher Garrigan was stalking because of his alleged contact with Daniel Lewis's children as a convicted child sex offender. Daniel submitted an affidavit which stated concern because his daughter's emotional and mental states put her in high risk of being sexually assaulted by a child predator. So now one has to wonder, why is Daniel so concerned with his daughter's emotional and mental states, and why isn't he working with counseling instead of trying to break up a relationship between his wife? Daniel indicated in the petition, sworn under penalty of perjury, that he had no knowledge of Garrigan harming the children, but he wanted the order to ensure that his children were safe. Daniel then admitted that he had not personally seen Garrigan around his children, and he had no direct knowledge of Garrigan's contact with the children. The circuit court entered a protection order against Garrigan on August 23, 2018. So now let's look at who is Teresa Lewis. Well, Teresa Lewis is an LPN. She worked at the Rapid City Medical Center Skin Institute, and she was awarded the 2020 Nurse of Excellence Award. So, does that seem like the kind of mother that would place her children's lives in danger? And when asked about Teresa, to tell her about herself, she said, well, I have 3 kids. Braden is a junior in high school. Ella just started middle school. And Logan is in 3rd grade. So during the time that Daniel Lewis was alleging child molestation and obtaining a false protection order on behalf of his children and further exposing his children to legal proceedings, 2 of them were in grade elementary school. Now remember that the people of South Dakota are the ones that have the power. They're a democracy, and they're the ones that enact the laws. And they specifically said under what grounds a stalking order or protection order could be issued. And it's found in Chapter 25-10-3.3 that says, first, the petition must allege the existence of domestic abuse as defined in 25-10. And if the court, upon review, finds that domestic abuse does exist, or that it does not exist, but the allegations do support the existence of stalking or physical injury, again, as defined in another statute in this chapter, then the judge may grant a protection order. Now, remember that Daniel's affidavit said that his daughter's state of mind placed her as a victim of sexual assault. State of mind. However, Daniel also testified he had never witnessed Garrigan's behavior or interaction with his children. So how can he allege that physical violence, sexual assault, or stalking has occurred when he has never witnessed such behavior? By law, the judge had to dismiss the action. And then further, in Chapter 22-19A-8, the petition for the protection order must include the actual allegations documented of stalking or physical injury as a result of an assault. And then a petition shall allege the existence of stalking or physical injury as a result of an assault or crime. All of these were not met. Not a single documentation that Christopher Garrigan had touched one of Daniel Lewis's children when Daniel Lewis was granted a protection order illegally in a Pennington County court. So Christopher Garrigan appealed this illegally entered protection order because, remember, there were certain grounds under which a protection order could be granted, and absolutely none of them had been met in a court of law, yet this was granted. he alleged a few things in his request for a appeal. One of them was that he was suffering consequences of this illegally entered protection order. However, the Supreme Court of South Dakota, under Justice Jensen and Justice Gilbertson, dismissed it as moot. First, they said that the protection order, by the time they ruled on it, had already expired. And second off, that Christopher Garrigan had failed to show that a protection order entered against him had any collateral legal consequences. So now we're going to see just exactly what legal consequences you suffer from having an illegally entered protection order. And in South Dakota Codified Law, Chapter 25-4-45.5, it says that when you award custody involving a minor child, the court shall consider if a conviction of domestic abuse has occurred, or a conviction of assault, or a history of domestic abuse. And part of that can be presumed just by the issuance of a protection order. However, it said that the history of domestic abuse may only be proven by greater convincing force of the evidence, such as the issuance of this protection order. And then in Chapter 25-4-45.7, it says, for the purposes of this chapter, in determining whether a history of domestic abuse occurs, they can consider the issuance of a protection order. So Justice Jensen and Justice Gilbertson of the South Dakota Supreme Court violated the South Dakota Codified Law by stating in their opinion that no legal ramifications occur from the issuance of an expired protection order. Now, who is behind all of this deception in the courts? And the answer is Mitch Johnson. He's an attorney at law, states under oath that he lies to win. His office is in Rapid City. Mitch Johnson happens to be the city attorney for Keystone, and also the city attorney for Hermosa. And lo and behold, he's the divorce attorney for Daniel Lewis, and Mitch Johnson is the divorce attorney for Timothy Evans. Now, America's civil litigation system affords individuals the privilege to file a lawsuit alleging a violation of law. However, they must litigate within the established parameters for filing a claim. These parameters are set forth in statutes, rules of civil procedure, local and court rules, and professional rules of responsibility and ethics. Every attorney who files a claim on behalf of a client is charged with the obligation to know these statutes and rules as well as the law that was allegedly violated. Now remember that Daniel Lewis was given the award for child molestation and all of that through the Sheriff's Department in 2022. Well, how did Daniel Lewis have collusion with Timothy John Evans? So first off, we're going to see what is collusion. And it's the secret or illegal cooperation or conspiracy, especially in order to cheat and deceive others. What was the grounds for this collusion? And the answer is the Brotherhood of Law Enforcement. This is being quoted explicitly from an actual police officer who is bragging on the internet, "I've been feeling good." Why? Because we're a brotherhood. We are brothers and sisters, part of a crazy and sometimes dysfunctional, highly skilled, dedicated family of people who are the last line of defense between the population we serve and total chaos. What could be better? And then this is taken from another webpage about the Brotherhood of Law Enforcement. And it says that the importance of loyalty to the Brotherhood cannot be overstated in the us versus them world of policing. Officers demonstrate their loyalty in many ways, but the most infamous way is the code of silence. What happens between brothers stays between brothers, no matter what. When a male officer does something stupid, dangerous, or illegal, he can count on his brothers to look the other way and keep their mouth shut. Now, I have the utmost respect for law enforcement. I have many family members that are law enforcement, and I did happen to marry a former police officer. However, just because you have good people in a police force doesn't mean that everybody's good. And this is a public exposure of the perversion of corrupted cops, not hands down the men and women who give their lives sacrificing for us every day. And I take my hat off to them 100%. But I am against the secret brotherhood, turning your head, looking the other way, biased justice. That's what this is about. So what's the pattern of deception? Well, Mitch Johnson, as their attorneys, almost simultaneously during the same time, advised both men to obtain falsified protection orders to obtain custody of their children. We're going to go into Tim's protection order at a later date. Mitch Johnson, then, when he was called on his deceptive practices, he informed the court that he had absolute immunity and the right to state false and defamatory statements as an attorney. So I actually took a screenshot of his quote, what he said right there, where Mitch Johnson stated, "An attorney at law is absolutely privileged to publish false and defamatory matter of another in communications during the course of judicial proceedings in which he participates as counsel." So let's remember Mitch Johnson's attorney clientele, the city of Keystone. Do the city of Keystone truly know what kind of man he is, and do they want him representing them? And what about the city of Hermosa? These are honest, hardworking South Dakota citizens who have no idea the attorney that they have hired to represent them. And then Mitch further stated that his ability and right for absolute immunity and his right to deceive the courts was found in the Restatement of Torts, Section 586 in 1977. So we pulled up the Restatement of Torts, Section 586, and found out that it was initiated for criminal prosecutors who would have to publish charges against accused going to a jury trial, not for attorneys in civil cases where the truth must be told. And further, the 1977 Restatement of Second Torts was overturned, because they are found by the American Bar Association to be outdated and inaccurate. So the American Law Institute's restatement of the third torts, released in 2000, clearly rewrote Section 586 that Mitch Johnson is now using as his defense in 2022. It was overturned 22 years prior, and it said that it complied with the American Bars Association standard that an attorney must tell the truth or it's considered professional misconduct. So the restatement of the third grants that attorneys only have immunity if the attorney has not practiced using deception or fraud, and if deceptive means are used, then that attorney has intentionally waived the absolute immunity which Mitch Johnson claims he has all the time. It further says that not only is the attorney guilty of professional misconduct, but they are then liable to civil lawsuits as well as the firm of which they represent, and they must pay damages for their intentional fraud. Now, the state of South Dakota legislature is comprised overwhelmingly of attorneys compared to any other profession. Remember that legislators are elected. However, more attorneys are on the Senate and House panels than any other profession. So, overwhelmingly, the people of South Dakota elect attorneys. These attorneys create the laws. You would think that these legislators, if they truly thought that an attorney could practice fraudulently and deceptively, they would have some loopholes in the laws. But instead, they have implemented the professional rules of conduct in South Dakota Codified Law, Chapter 16-18, Appendix, where it has multiple statutes requiring an attorney to be truthful in civil cases, and if caught in the far-reaching web of deception, then that attorney is to be disbarred from practice. So specifically in these appendix, it's Rule 3.3, Candor towards the tribunal. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to timely correct a false statement of material fact or law, or fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of his client. So in other words, if this attorney is claiming that the law says this, defending his client because of that, and then the law is actually adverse or opposite of what the attorney says, that attorney has to be forthcoming. He's not allowed to misrepresent the law at all. But this is what Mitch Johnson claims he's allowed to get away with 100%. And then again, further down in this same appendix, South Dakota rules enacted by the legislature, Rule 4.1, truthfulness in statements to others. In the course of representing a client, an attorney shall not make a false statement of material fact or law to a third person or fail to disclose a material fact when that disclosure is necessary to avoid assisting a criminal or fraudulent act. Now let's refer back to Tim and Rachel's, Timothy's original divorce filing. He claimed he's a resident of South Dakota, and then it was proven that he wasn't, and Mitch Johnson, by law, had to recant all of this and give the judge knowledge that Tim was not a resident of South Dakota when he filed, but instead they twisted the law and Judge Connolly condoned it. So, how does the South Dakota Supreme Court see this? And it was answered in this case, which Justice Jensen ruled on in 2022. And he states that we conclude for the same reasons we discussed in this previous case law. In representing a client, an attorney should not be free to substantially assist their clients in committing the torturous act of committing fraud upon the courts and personal injury that results from it. So, Daniel Lewis swore under penalty of perjury with Mitch Johnson as his attorney that his children suffered all of this stuff at the hands of that man that his ex-wife is now dating. And Timothy John Evans, the court file is full of it, and the courts just look the other way. And the answer to that is because both of them were former police officers. Daniel Lewis still is. Now, the South Dakota codified law enacted by the people also states that any final judgment entered by a court under grounds of fraud needs to be vacated. And again, Reeser versus Reeser is case law, and it says attorneys must be fair and forthright with the courts, states all these case laws. Moreover, the requirement of candor goes beyond the tribunal. It goes past simply telling a portion of the truth. It requires every attorney to be fully honest and forthright. And then they further ruled back in 2004 that it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. So going back to Mitch Johnson, was he debarred for fraud? Or was he rewarded for practicing deceptionally? Well, let's just say that Mitch Johnson intentionally represents law enforcement officers to, quote, stay in the family of that secret brotherhood. And if you look at the case history of who Mitch Johnson represents, he intentionally represents multiple law enforcement officers that work in Pennington County. So let's remember that Timothy John Evans was a police officer in Havre, Montana. This was covered in episode 4. Timothy John Evans specifically targets law enforcement officers. So in 2018, Timothy John Evans, when he stole Rachel's children from her, he specifically removed Rachel's children from all of their friend base, and he implemented them in a completely new social scenario, and then he dictated who the children were allowed to be friends with. Then Timothy intentionally sought out law enforcement officers' children for Rachel's children to be friends with. And then Tim started to brag to Rachel that his targeting of other law enforcement officers' children as Rachel's children's friends were so that he could develop relationships with the police officers and sheriff's deputies to keep Tim out of jail. Now we're going to look at some of the men that Tim targeted. One of them was Mark Eisenbraun. Mark Eisenbraun is a lieutenant with Rapid City Police Department, and he has... I don't have any personal stuff on Mark except that he's the father of one of the people that Tim targeted. This is interesting, though, because the body cams that the sheriff's deputies wear and the police officers wear, these body cams come into discussion at a later time when we talk about Deputy Fredrickson, who is a friend of Tim's, and he admitted on his body cam that he spends extensive time with Tim up at Rachel's house with Rachel's children present. And Mark Eisenbraun worked to implement where every sheriff's officer, deputy, and also police officers wore these body cams. And then he told a statement that it's a misconception that these body cams are primarily a tool to hold officers accountable for their actions. The cameras are a tool that will help us relay a more accurate picture of criminal incidents into the court system. So Mark is saying that it's not something to keep the officers accountable, it's something to help prosecute criminals. Now, Mark is married to Jill Eisenbraun. They have 3 daughters, and Timothy specifically targeted one of their daughters, who Rachel is, out of the privacy of children, not naming. I have multiple pictures of my daughter Rylan and this precious little girl. She's now a teenager. She's almost a senior. Anyways, being together and the time I spent with her, she's an amazing young lady. I don't want to bash them at all. I'm simply saying Tim targets law enforcement's children to be roped into his collusion and deceit. Jill Eisenbraun happens to be one of the female business owners that has employees. Of those only 3,000 in the state of South Dakota, she happens to be one of them. And Timothy filed criminal allegations against Rachel in 2021 on behalf of Mark Eisenbraun's daughter and Rylan, asking to take Rachel's parental rights away. Now, like I said, I have utmost respect for the men and women who serve our country in a police officer or deputy role, and this in no way, shape, or form has anything to attack those men and women who lay their lives down every day. But this is about perverted people who work in the law enforcement occupation simply so that when they commit a crime, they have absolute immunity. And the other person that was specifically targeted happened to be a police investigator's son, and Tim made sure that Rachel's oldest son, and they're now seniors, were best friends and spent tons of time together. I, out of courtesy, choose not to disclose this officer's name, but it's in the court records, and Tim extensively testified to Rachel's son's relationship with this undercover agent's son during court. Of note, the Department of Justice describes police undercover work using deception by a police agent that results in obtaining information and evidence to build a criminal case. So the Department of Justice on their webpage states that a police officer is to use deception. Well, maybe that's a national problem. And then the Rapid City Police Department's criminal investigations has the responsibility to, and they have 2 different divisions. They have the crimes against persons and the crimes against properties. Now remember, Timothy John Evans was guilty of raping Rachel, and a police officer, sheriff's deputy tried to arrest him. There was actually a request for a warrant for Tim's arrest for raping Rachel that the law enforcement officers brought forth. Rachel had nothing to do with it. And Tim specifically targeted an officer who investigates crimes against persons. Therefore, he targeted the child of a police officer who would be investigating Tim for rape. That's how this works. Now, is Justice Jensen of the South Dakota Supreme Court innocent? And the answer is no. He's just as guilty as this collusion because he knows that it's happening. He's been given all the evidence, and he's turned his head the other way and covered it up. So again, justice for South Dakota. We are asking the people of South Dakota to stop this. Your state has a crisis in it right now. This crisis is continue to go downhill, and pretty quick you're going to have a massive, massive problem that's not being fixed unless the people of South Dakota hold Governor Noem and Justice Jensen responsible to the oath that they swore to uphold, and stop turning their heads and start fixing all this perversion and collusion. Stay tuned for episode 9.